This morning we are indeed joined by one who can give us a clear indication as to where we are, what are the obstacles, what are the challenges for Trinidad and Tobago adopting the Caribbean Court of Appeal. The former Jamaican Prime Minister P.J. Patterson, interestingly, criticized Trinidad and Jamaica's delay in adopting the Caribbean Court of Justice as their final court of appeal. He said that after 50 years of political independence, the two most populous and arguably most advanced social, political, and economic states of CARICOM continue to hang on to the most colonial of vestiges. Indeed, this seemed to be one of the significant challenges facing the court today: the reluctance of Caribbean states to adopt the Privy Council, to abolish the Privy Council, that is, and adopt the Caribbean Court of Appeal as their appellate court. The issue has provoked debates on the relevance of the court and prompted analysis of its challenges and achievements over the last decade. My guest this morning is President and of the Law Association of Trinidad and Tobago, Reginald Amora, Senior Counsel. He has been elected chairman of CARICOM's Council of Legal Education. The council operates 3 law schools in the region: the Normal Manley Law School in Jamaica, Hugh Wooding in Trinidad and Tobago, and Eugene Dupuch in Bahamas. A member of the Inner Bar of Trinidad and Tobago, he has practiced in many areas, and his specialty is commercial, constitutional, and public law, including election law. Labor relations is also inside of there. In other words, I can spend a long time describing him. It is our pleasure to have with us this morning Reginald Amora. Thank you so much for joining us, sir.
Good morning, Rennie. Thank you. Pleasure to be here.
It is good to have you here. The Caribbean Court of Justice mission is to protect and promote the rule of law as a court of final appeal and as guardian of the revised Treaty of Chaguaramas by guaranteeing accessibility, fairness, efficiency, and transparency, delivering clear and just decisions in a timely manner. One of the striking ironies is that even though the court is a product of the Treaty of Chaguaramas, which is physically located here. The court is physically located here. We have not adopted it as our final court of appeal. Question is, how does one reconcile this?
Well, the irony is perhaps even greater, and I'll explain what I mean by that. But let me, to be fair to my constituent membership of the Law Association, make one point very clear. I'm here as the president of the Law Association, yes, but the views among the membership of the Law Association, practitioner attorneys in Trinidad and Tobago, is not unanimously in favor of abolishing the Privy Council and acceding to the Caribbean Court of Justice. So that I will certainly, and I am a very strong proponent of abolishing the Privy Council and acceding to the Caribbean Court of Justice's appellate jurisdiction, but what I say is not intended to represent a unanimous view of the membership of the profession in Trinidad and Tobago. So I just want that to be very clear.
That qualification is very important and very striking because many felt, including yours truly, that the primary objection to the CCJ was a case of political will. But you were saying even among the practitioners, there are questions as to whether this, in fact, is the proper direction to go.
Yes. But to address your opening remarks when you spoke of the irony, I was about to say that the irony is even greater because not only do we have, as the founding international treaty, the origin of the concept of the Caribbean Court of Justice being the Treaty of Chaguaramas, which is, as we all know, Chaguaramas in the Republic of Trinidad and Tobago, but also the treaty which brought the Caribbean Court of Justice into existence in 2001 was brought into existence by the signatory of the then Prime Minister, the Honorable Mr. Basdio Pandey, on behalf of Trinidad and Tobago, without any reservation being stated at all. And the significance of that is that some countries, when they signed on with reservations. So, for instance, St. Vincent and the Grenadines was one such country. Trinidad and Tobago signed on with no reservation. In other words, there was no basis at the point of signature to express any question as to the inevitability of Trinidad and Tobago acceding to the full appellate jurisdiction of the Caribbean Court of Justice. And in point of fact, the irony is even greater when one recognizes that consequent on the signing of the treaty, Trinidad and Tobago was able to persuade all of the member states of the Caribbean Court of Justice and CARICOM to have Trinidad and Tobago as the headquarters of the court. So the court is situated in Port of Spain.
Mm-hmm.
And Trinidad and Tobago is also the headquarters of the Caribbean Court of Justice Trust Fund, which is the trust fund that finances the court. That's also here in Port of Spain.
The physical building, the financial support is all housed here.
All the staff, all the judges, all the appeals are heard here, except, of course, through video linking of the court back to the Caribbean member territories. But it's all here. And Trinidad and Tobago. And I should add the point that Trinidad and Tobago is actually a member of the court as it already exists in what is known as its original jurisdiction, because the court has two levels of jurisdiction. The original jurisdiction, which is the jurisdiction by which it interprets the Treaty of Chaguaramas in disputes that exist between member countries of CARICOM. And Trinidad is a full member of the court in that original jurisdiction, but to date has not passed the relevant legislation to become a member of the appellate jurisdiction of the court, thereby abolishing the Privy Council.
Would like to get into the areas of divide where folks are not on board with this. But before that, you just mentioned what is necessary for Trinidad and Tobago. We have to put legislation for the CCJ to replace the Privy Council as the country's highest appellate court. The Trinidad and Tobago Constitution must be changed, and this being one of the most entrenched provision, which would not allow for a simple majority to have it removed. What needs to be changed, altered, and amended is dependent on an understanding among all parties as to bring on that necessary majority. So what is wrong? What is the primary objection you were hearing why we are unable to get that majority to move forward in changing the legislation in Trinidad and Tobago?
I'm not sure, to be perfectly honest, Rennie, if I understand what the objection is. I've heard arguments to suggest that we are not ready. I've heard arguments to suggest that we should fix our national courts before we become part of the Caribbean Court of Justice. And I suspect, and I emphasize this, I suspect that in Trinidad and Tobago we lack the confidence to feel capable of taking charge of our own affairs. But as to the actual objection, what I've heard are simply, we're not ready. Our domestic courts are not functioning. Why should we therefore go on to the Caribbean Court of Justice? And I've heard arguments to suggest that the Privy Council would be more impartial in delivering quality justice in Trinidad and Tobago than our courts.
I'm sometimes slow on a Sunday morning, so you may want to help me out with this. In other words, my engine is not running at optimum, so I shouldn't go on the road.
That's right.
Tongue is tightly placed in cheek, guys. Reginald T.A. Amor, Senior Counsel, is my guest this morning on Brunch. Detractors have said that there are a lot of opportunities for bias and political interference by the judges. A perception currently exists that all of our institutions in TNT have been compromised, more than just fixing our courts. All the institutions have been compromised, and that of the Privy Council must be an organization that is detached from the Caribbean society and as such better positioned to bring impartial justice. I think from your concerns you answered this, but I will ask it anyway. Do you see any validity in those concerns?
No, but that is not to say that there isn't some reason to address those concerns. There is real reason to address those concerns. I mean, if we were to break it down, the question of bias, there is a lot of opportunity, your question suggests, for bias and political interference. And it begs the question, who is it that we don't have the confidence in? Is it the judges? And is there evidence that our judges are being politically interfered with? I don't think there's any evidence of that. So then is it perhaps that we don't have confidence in our politicians, our national leaders? That is something that begs the question. And when we look at what is taking place across the world, when we look, for instance, at Brexit in the United Kingdom, we look at what is happening in the United States right now in the presidential campaign, we have to accept that we are all nations in the making. We have an evolutionary political evolutionary process to go through. We have a growing up process to go through, a process of maturation. We can't pretend that we are all at a perfect state of existence at any point in time.
Mm-hmm.
And we have to have the confidence in the Caribbean, in Trinidad and Tobago, to accept that if we don't take charge of our own affairs and accept that along the way we will stumble, we will make mistakes, we'll never be in charge of our affairs. I don't have any reason, and I have seen no evidence to suggest that the judges of domestic courts and, again, judges of the Caribbean Court of Justice are susceptible to political influence. But if that was suggested with any seriousness, then the question really requires an answer from the politicians more than it requires an answer from the judges.
6 minutes after 11, my guest is President of the Law Association of Trinidad and Tobago, not speaking in that capacity. Reginald Moore, Senior Counsel, he has represented clients before the Judicial Committee of the Privy Council. We're talking about the Caribbean Court of Justice. While the CCJ operates as an independent judicial body with a rigorous process for the selection of its 7 judges, many say mistrust and suspicion still pervade in the minds of both governments and population across the region with regards to its capacity for impartiality and sound judicial decisions due to, importantly, domestic politicization of issues that will come before it. Do you agree with that?
I don't. And there were a couple instances very recently of politicians speaking out to express a lack of confidence in the Caribbean Court of Justice. And those instances actually demonstrate the point that I'm making, that the problem really lies with the politicians, not so much with the judges. And those 2 instances, interestingly enough, come out of St. Vincent and the Grenadines, which is the one territory that expressed a reservation when they signed on to the court. The 2 instances I refer to are in the case of Mr. Sir Son Michel, the former Prime Minister of St. Vincent and the Grenadines, actually wrote a column into the newspapers last year, 2015, reflecting on his experience of having won a case before the Privy Council in which he had been the subject of a commission of inquiry in St. Vincent and the Grenadines, which exposed him to severe criticism for politicizing his government. And in the Privy Council, he claimed to have been vindicated because the Privy Council found that they did not agree with the Eastern Caribbean Court of Appeal. So he cited that as an example why he has more confidence in the Privy Council. What is ironical about that is that in the political process and the constitutional framework by which judges of the Eastern Caribbean are appointed, in the Eastern Caribbean, the Chief Justice of the Eastern Caribbean can only be appointed by unanimous agreement of all of the heads of government. And in San Michel's period as Prime Minister of St. Vincent and the Grenadines, there were long periods when a particular judge was not allowed to become Chief Justice of the Eastern Caribbean because Mr. Mitchell exercised his right of veto to block that judge because he had been unhappy with the decisions of the particular judge. So it's intriguing to have a politician who has had the particular experience that Sir Son Michel has had to express a lack of confidence in the independence of the judges. The other recent example is a comment attributed to Mr. Ralph Gonzalez, the current Prime Minister of St. Vincent and the Grenadines.
He's a strong advocate of the CCJ.
Well, he allowed himself to comment, I believe, recently on the fact that in the cases of the Shanik-Myrie decision and the Trinidad Cement decisions, that those raised questions as to the extent of the extent to which the judges of the CCJ were interfering with the process of governance of the Caribbean islands.
Judicial activism.
And it's unfortunate because when you look at the treaty of the Caribbean Court of Justice, it is allowed to make interpretations of Caribbean instruments. And both in the case of the Trinidad Cement case, that was a case of tariffs out of Guyana. And they ruled that Trinidad Cement had made out a case for the tariffs in Guyana being infringed. That's a pure question of legal interpretation, which the Caribbean Court of Justice had the courage to pronounce on, notwithstanding that they were holding against the government of Guyana. And that's therefore a good example of judicial independence, the very thing that people say the Caribbean Court of Justice is not going to be capable of. In the case of Shanik-Myrie, who was the young Jamaican lady who was stopped in Barbados and strip searched and brought a case before the Caribbean Court of Justice. What the Caribbean Court of Justice did there was to apply well-known principles of legitimate expectation to say that that young lady had entitlements on that doctrine to be treated equally and to be treated in a particular way, to be allowed entry into Barbados. And therefore, they called the Barbados government into account for violating that young lady's rights. Again, an example of judicial independence on the part of the court. And we find the politicians criticizing them. So what better examples do we need of the very independence of the court to allay the concerns of the people?
11 minutes after 11 o'clock on a Sunday morning, October 16th. Many may wonder, hey, listen, I like what they're saying, but I'm not too clear what they're saying. There's always the risk in this business, senior counsel, of doing the behind baseball discussion where we know where we are going with it, but there are many people who would like to follow where we are and are not too clear on it. Synopsisize, if you will, before we continue analyzing some of the challenges facing the CCJ. Synopsisize, if you will, for the uninitiated. What is the purpose of the Caribbean Court of Justice, and why is it important that every citizen of the region understand its importance and its adoption?
Thank you, Rennie. The purpose of the Caribbean Court of Justice is to provide a final level of appeal in the access to justice that citizens have from every island of the Caribbean on their right to fair adjudication. At the moment, the existing system is you have the magistrates and high courts at the first level, and then from there you can appeal to your local court of appeal. In Trinidad and Tobago, our court of appeal is headed by Chief Justice Ivor Archie. And from there, you then have a final right of appeal to the Privy Council. The purpose of the Caribbean Court of Justice appellate jurisdiction for Trinidad and Tobago is to replace the Privy Council so that an issue will finally reach to that final body. It will be determined and the parties have to regulate their relationships with each other. There is no further appeal. So that's the purpose of the Caribbean Court of Justice as a final court of appeal. Why should we have the Caribbean Court of Appeal in place of the Privy Council? Many reasons, but one of the most telling reasons is simply affordability.
That's right.
It is prohibitively expensive for citizens of the Caribbean to have access to the most fundamental right, and that is the right of access to justice. It is prohibitively expensive for them to get to the Privy Council, and therefore a very small percentage of cases end up in the Privy Council. If you are going to give people a legitimate right of access to justice, then they must have the ability to afford getting to the final court of appeal.
And many folks who don't understand that must understand it is really economic or financial discrimination. You give access to those who can afford it, and you're depriving the wide range, the majority of citizens in the Caribbean from the right to that same access to justice.
That's right.
Mm-hmm.
Yeah. So the importance of access to justice is important, but equally important, perhaps even more important, although I wouldn't, ask to be held to account as to which is more important than the other, is that we must manage our own affairs. And our Caribbean Court of Justice comes of judges of the Commonwealth, not just the Caribbean. We have at the moment on that court judges outside of Trinidad and Tobago, Justice DeWitt, Justice there's another Justice Hayden out of the UK, but the majority of them come from the Caribbean. They understand our culture, they understand our history, they understand us as a people, and therefore they are able, competent, and best positioned to adjudicate for us for our disputes.
In the wider interpretation, if you understand the culture of the people, you are best in a position to make a decision or to give an opinion on.
Indeed. In fact, just a few weeks ago at the opening of court, Professor Hollis Liverpool, better known as Chalk Dust, opened the Trinity Cathedral prayer of the Hall of Justice of the new court term with a very, very captivating address. He doesn't want it called a lecture. I refer to it as a lecture. He said it was an address. And it was accompanied with excerpts from the Calypsos. And what he was about is the essential point that we have to produce lawyers and judges who are part of and understand our culture. And until we have our final court of appeal equipped with people who are of us, then we are, in the words of another professor, Richard Drayton of the University of Oxford, we are allowing our critical decisions to be made at the periphery of our society.
You have papered independence, but judicial dependence.
Correct.
Is what you're looking at. Now that we have explained to our listeners the importance of the Caribbean Court of Justice, let's go back into some of the concerns with my guest, Reginald T. Moore, Senior Counsel, who is president of the Law Association of Trinidad and Tobago. He has served as an acting High Court judge of the Supreme Court of Trinidad and Tobago, and as a senior member of the Council of Law Association and the Law Reform Commission. Concerns have been raised by the lack of ethnic and gender diversity in the composition of the judges, given the multicultural nature of some Caribbean societies. The merits or demerits of this argument?
Well, I think it would be unsafe, to be perfectly honest, if we were to ever provide as one criterion for the selection of people on the basis of merit, if we were to ever to provide that people must be selected on the basis of ethnicity. And I entirely reject the thought, far less the suggestion, credibly or otherwise, that a criterion for election, nomination to any serious institution should be based on ethnicity. At the moment, the criteria which the Judicial Legal Service Commission is entitled to take into account in appointing members to the court are high moral character, intellectual and analytical ability, sound judgment, integrity, and understanding of people and society. That is Article 4, Sub-Article 11 of the agreement which establishes the Caribbean Court of Justice. I can understand a concern out of Trinidad and Tobago or out of Suriname, which wishes to become part of the Caribbean community and the CCJ, or out of Guyana, where we have a strong ethnic mix. I can understand a concern that we would like in an ideal world to have a broad cross-representation of all hues, colors, and ethnicities. But our constitution mandates us to rise above that. And if we were to extend that argument with any credibility, and I don't think it has any credibility, then how do we prefer the Privy Council to the Caribbean Court of Justice? I don't see anybody on the Privy Council, which we claim, some of us claim is better than our best capacity. I don't see anybody on the Privy Council that varies much in terms of ethnic hue or coloration.
Very shallow argument indeed. The former Prime Minister, Kamla Bissessa, although agreeing the ascension to the CCJ is inevitable, alluded to a national referendum, arguing that the public has lost confidence in the country's justice system, and by involving the people in the decision, there would be a stronger sense of ownership and faith in the CCJ. Do you agree with that assessment, and is a referendum needed?
I'll answer the last part of the question first, Rennie. A referendum is not needed. There is no legal basis in the Constitution or any other laws that require a referendum. What we need is in the lower house a 3/4 majority. So that means that both political parties have to collaborate, because no one political party has a 3/4 majority in any house. And in the Senate, we need a 2/3 majority. So we need collaboration between the elected representatives on both sides of the divide. But as to whether we need a referendum or not, I entirely accept and agree that it is important that people must own the process of their decision making. And if a referendum could be organized to reach out to people for the purpose of education and for involvement, so that ultimately people have the confidence that they've had a say in the process, then I would support that. My strong caution, however, if we are going to go for a referendum, not because we need it, but because we want to validate the process of ownership, we must keep the politicians out of it. Because history has shown that referenda get very convoluted and miss the point, because what happens in a referendum that is designed to accomplish purpose A is that the message becomes mixed with mixed political driven agendas, and people end up making a decision on decision A with reference to considerations that have nothing to do with decision A. So we'd have to be very careful. I was thinking about that question actually coming here, and it occurred to me that perhaps the countries which have still not yet come onto the CCJ might want to collaborate among themselves and try to get a Caribbean body, not unlike the American Presidential Debate Committee, which can bring together well-respected members of the Caribbean community who would fashion a referendum process which would be managed entirely without political involvement and go to the people on an informed basis. We are doing it in one sense in the Law Association in Trinidad and Tobago. We've already had one symposium in which we've reached out to our membership to educate them on the issue. Do we go for the Caribbean Court of Justice and replace the Privy Council or not? That occurred earlier in 2015, and we have another one that we are in the course of putting together for early February of next year. And what we want to do is we want to make it into, if possible, a live streamed event that will include the public, so that the public can be informed of the legitimate arguments for and against, but keep the partisan political agendas out. Don't distract from the real question.
When it's addressed among programmers, the question is how many people would really be interested in a conversation on the Caribbean Court of Justice. I have been after you, and take that gently. I've been attempting to get him here for a very long time, and the reason for that is exactly what you just said. I feel that if there is a conversation that has to push politicians to action, it is the citizenry, and informed citizenry is your best watchdog for democracy. That being the case, they must first understand it.
Precisely.
And while folks say a Sunday morning conversation could be better served in this conversation or that conversation, this is the ideal conversation, because even when we look at the length of time it takes for issues to go to the Privy Council, even when we look at the conditions set out by the Privy Council for us to carry out a death penalty, even when we look at the access to justice as you articulated earlier, all these issues are tied up in this. And if we're to move forward, we must get a full understanding of what is at stake. And we must take the opportunity, like this one we have with your esteemed self, to explore it and make it clear to people. David Abdullah said that there would be need for constitutional reform first to make a referendum legal. I mean, this is back on the question of the former Prime Minister asking for a referendum. David said there would be need for constitutional reform first to make referendum legal before the government can remove the Privy Council. He added that if there was greater participation from the citizenry in government issues, the political system in the country would regain their faith in the justice system, basically echoing what the Prime Minister has said. As far as constitutional reform is concerned, as it relates to the CCJ, what is your view on David's observation?
Well, I know David Abdullah. I have a lot of regard for David Abdullah. I think that his argument is putting the argument back to front with respect. We do not need constitutional reform by way of the introduction of provisions in our constitution for a referendum in order to go to the to the Caribbean Court of Justice. All we need is for the elected representatives who exist now to arrive at a sufficient agreement to give us the requisite majority in Parliament. And if they have that majority, the legislation will be passed to bring the CCJ on board as the final court of appeal, and concomitantly at the same time to abolish the Privy Council. So we need not go to reforming our constitution for purposes of passing a referendum. But certainly, and I think David would accept this, we can go to the people on an informed basis, and I congratulate your radio station for doing precisely that right now. We can go to people, and there's every good reason why we should take the discussion out into the communities and encourage people to call in and express their views, address those concerns, and have a full national discussion, so that when the parliamentarians come to vote on the issue in the House, they already have the mandate to go to Parliament to represent their people. They will have heard what the people have said, and they will therefore hopefully listen to what the people have said. We don't need to amend the Constitution to enable that conversation.
It is a question of the people moving the politicians, because for many of them it is convenient to find every pretext to avoid becoming truly independent. You articulated artfully earlier the question of us being dependent or afraid to cut the umbilical cord and stay locked into Mother England or to our prior system. And that is something I want to explore when we come back. And we're going to take a little break right now and go to the Black Stallion, who kind of works with what we are talking about, is the ability to bring the message to the people in a way that they understand it and understand that independence is not just signing a piece of paper, but is having independence in every aspect of your existence. You cannot be half pregnant is what I remember. You're either pregnant or you're not. Make up your mind where you are. It's kind of difficult when you want to keep one foot on land and keep one on the ship. Eventually what happens is the waves will move the ship out and you'll be split in two. There will be no you. Reginald T.A. Amora, Senior Counsel, is my guest this morning. He is, as I aforementioned, the president of the Law Association, but not speaking in that capacity this morning. Black Stallion just spoke to the mindset of the Caribbean man, being able to liaise, being able to influence, being able to educate, being able to elevate his fellow man and coming to a consensus. There seemed to be an unwillingness of many people to accept that we are now independent. There seems to be a mental slavery, I think is how Bob Marley phrased it, that folks refuse to remove the yoke, cut the umbilical cord, unlock the chains, and accept a CCJ. Give me an explanation, the best one you have from your vantage point, sir.
Rennie, it's about self-esteem. It's about self-confidence. Caribbean man, as Black Stallion reminds us, is a concept that we have to grow into. We have to earn the right to be our own people. And we cannot postpone that anymore. Mm-hmm. I always give the example when I talk about this very question, at what point, your question is, if not now, when? At what point do we go to the Caribbean Court of Justice and abolish the Privy Council? I always give this example. Mm-hmm. For those of us who are parents, and some of us are, but whether we're parents or not, all of us have nieces and nephews or friends who have children. There comes a point in the life of every young person where the parent, the adult, has to make the very difficult decision to open the door and allow that person to walk out. And do we do that young person a service by wrapping them in cotton wool and locking them in their bedrooms and afraid to allow them to go out, stumble, pick up themselves, dust themselves off, and march on into confidence? Mm-hmm. Do we confidently expect that we do our children a service to be afraid to ever allow them to open their wings and fly?
I like that.
And that's what it's about, this argument about we are not ready to go with our own final court of appeal, and therefore we must hang on to the coattails of the Privy Council, people who are thousands of miles away from us, not of our country, not of our culture, not of us, who, whenever they are faced with the difficult decisions, say that they will defer to the decisions of the Court of Appeal because they are not of us. And there is a contradiction that many of us don't appreciate. If we look at our Constitution of Trinidad and Tobago, for instance, in the most difficult decision-making that any court could be asked to determine, election appeals, the Privy Council has no role. Our Constitution declares our Court of Appeal as the final decision-making authority.
And that is the essence of our democracy.
That's right. And we have had several appeals to our courts of appeal in Trinidad and Tobago over the years. The Court of Appeal of Trinidad and Tobago has pronounced decisions. They have been confidently understood, accepted, and life has moved on, and our societies are better off and stronger for that. We have appeals going to the Court of Appeal next month on election petitions. Are we saying that our court is not good enough to determine whether a political party is validly elected to govern us for the next 5 years, and we should send that to the Privy Council? Our constitutional founders decided 50 years ago that that was not going to be the case. Right. Take, for instance, what is happening in the United States right now. Mr. Trump has just declared, because he sees the writing on the wall, that the election is rigged. It is one of the most testing questions that any self-respecting nation will have to determine for itself. We have always determined it ourselves with our Court of Appeal. Why, therefore, do we not take that final step to abolish the Privy Council and move on. It's about self-confidence. And I think that our national leaders have to remove the partisan political agendas. They have to speak to the people on the issue. Are we ready or not? Not with respect to issues of ethnicity and other narrow partisan political issues. We have to look at it and say to our people, we must take that step because inevitably we have to be in charge of our affairs.
The Black Stallion said that the inability to articulate the message is one of the problems we have. I think I could use part of what you just said to do exactly that. The current occupants who are resisting the acceptance of the Caribbean Court of Justice are in fact chaining and denying the future of the region from moving into an area of self-determination.
That's right.
And that is the analogy to the adult that my guest alluded to.
And I go back to the point that I made. When in 2001, Mr. Pandey, the Prime Minister, signed on to the Caribbean Court of Justice, he did it with confidence. He did not express, as he was entitled to, any reservation. Why, therefore, do we not take that final step now?
In case you just locked in with us, my guest is Reginald T.A. Moore, Senior Counsel. We are talking about the Caribbean Court of Justice, why it is necessary that we adopt it, if not now, when? There is the question raised by many people, and I want to get to your individual, your members of the Law Association, some of the areas in which they depart from a consensus on that. But I do want to go into something that we just dealt with, which is our local judiciary getting its own funding, getting its own money, but still it's coming from the government.
Yes.
And folks, in discussing the independence of the Caribbean Court of Justice, wonder where the finance is coming from and whether that will be used as a puppet string to control the Court of Justice. Explain that to us, please.
Yeah, I mean, in our domestic situation, the government of the day is the organization that provides the financing for the judiciary of the domestic courts. Now, we have to appreciate that the Caribbean Court of Justice is not a national court. It is not a domestic court. It is an international court. Mm-hmm. There are legitimate concerns that have existed from the very beginning, and at the opening of every law term, we have had former Chief Justices, Sir Hugh Wooden, Mr. Justice Sharma, Mr. Justice De Labastide, and Mr. Justice Archie, making the point at the opening of term every year for many years now that the judiciary needs to have its own independent budget. Mm-hmm. Now, there has been progress in that regard in the 2015 budget, which was read by the Minister of Finance. So one hopes that we've made that quantum leap, but it's still a work in progress. The difference with the Caribbean Court of Justice is that the framers of the treaty that established the Caribbean Court of Justice recognized that for the Caribbean Court of Justice to function independently, not only did we need to have the judges appointed independently of any political involvement, and there's a regional judicial and legal service commission for that, which I'd like to talk about very briefly. Mm-hmm. But we have a Caribbean Court of Justice trust fund, and that trust fund started with seed money from the Caribbean Development Bank at inception, and has done an exceptional job since it's in its beginning of continuing through to fund the Caribbean Court of Justice independently of Caribbean governments. That trust fund consists of the Board of Trustees. It consists of the Secretary General of CARICOM, the Vice Chancellor of the University of the West Indies, the President of the Insurance Association of the Caribbean, Chairman of the Association of Indigenous Banks of the Caribbean, President of the Caribbean Institute of Chartered Accountants, President of the Organization of Commonwealth Caribbean Bar Associations, Chairman of the Conference of Heads of the Judiciary, that's one rotating Prime Minister ever so often, President of the Caribbean Association of Industry and Commerce, and President of the Caribbean Congress of Labor. That's the Board of Trustees that runs the financing of the Caribbean Court of Justice. It is headquartered here in Trinidad, and in spite of the vicissitudes of the fluctuations of the international performance of economies and bonds, etc., they have done an exceptionally good job of having at the last, now I say this subject to one thing, at the last point at which I had checked, starting with a fund of $100 million US dollars at 2015, the fund was still in credit to the tune of about 96 million. And that's after more than 10 years of existence of finance in the court. The last report of the Caribbean Court of Justice Trust Fund has just been issued. I actually got a copy of it as president of the Law Association last week. I haven't yet read it, so the figures that I've just given are subject to my reading that. But the short point is, this is a fund that is independently managed with no potential for interference by governments, and the court, therefore, is on a sound economic footing, independent of any political competence or allegiance.
You have removed the possibility of interference, reduced it by 90% when you say there can be no manipulation of the finance going to the body that would in any way interfere with that. The Myrie case, senior counsel, the Myrie case capitulated the CCJ into the limelight and raised the question as to whether the decision would result in a backlash against intra-regional immigrants that can foster tension between states in the regional integration movement. It was evident in the tensions between Trinidad and Tobago and Jamaica in the wake of the attempts by two groups of Jamaica to enter Trinidad and Tobago in 2013 and 2014. The question is, the CCJ, while we continue to examine possible or arguments as to why we should not have this or pitfalls for this organization, do we risk regional harmony as a result of some decisions that may come before the court?
The Myrie case is a very important case in a number of respects. It is one of the cases that demonstrates the competence of the Caribbean Court of Justice in an area in which the Privy Council would never be called on to make a determination. Secondly, it is a case which demonstrates the adherence of the Caribbean Court of Justice to provide for legal certainty, notwithstanding the fact that in doing that, it might offend sitting governments. And thirdly, the Myrie case is a living example of the Caribbean Court of Justice giving life to the dream of every Caribbean person, and that is the dream of being able to move freely through the Caribbean to do all the things that Caribbean people do. They marry, they love, they live, they play sport, they do business with each other. That is the essence of being a Caribbean person. And that decision has epitomized that. Inevitably, decisions of any court, whether it be the Privy Council, a national domestic court, or the Caribbean Court of Justice, is going to step on corns, and it is going to exacerbate relations between states. And the fact that the Caribbean Court of Justice had the courage to make that decision in spite of stepping on the corns of the Barbadian government, and I gather on the corns of Mr. Ralph Gonzalez of St. Vincent, it was able to do it in a reasoned, forthright way, applying all principles of law, the principle of legitimate expectation. If I can just tell you very briefly what that case did. What had happened there was that certain of the provisions in relation to freedom of movement had not been incorporated domestically in the Barbados legislature. Miss Myrie arrived and she said, but I am a Caribbean citizen, I have the right to enter this country, and she was kept out. She was strip searched, she was treated in a way that was quite deplorable by the customs officials. And at the end of the day, the basis on which the Caribbean Court of Justice found that her right had been violated is they looked at the pronouncements of cabinet ministers of the various governments over a period of time, notwithstanding the fact that the Barbados government had not passed the legislation to incorporate that element of freedom of movement. And they ruled that by the pronouncement of the cabinet ministers, they had created a legitimate expectation on the part of a Caribbean citizen such as Miss Myrie that she would be allowed unfettered access into Barbados for the purpose for which she was coming. And that is the doctrine of legitimate expectation is a very vibrant area in which courts are developing a rule in public administrative law that is holding governments to account. And the Caribbean Court of Justice faced that challenge squarely. They pronounced, and I do not believe that it is doing anything to exacerbate friction. I think, on the contrary, it is giving confidence to Caribbean people that they have a court who will vindicate and pronounce their rights if those rights are violated.
It is always the hope of many aspiring countries to be first world. And I think in a case like this, you can look at the example of a first world. President Obama is not always a very happy camper with the Supreme Court. Trust me. A lot of decisions that are made by an independent body is above the consensus, a consensus, even if a population say that this seems to be this way, the rule of the court is not to follow popular belief, but to interpret what is and pass the blame where it has to be passed. Reginald T. Amora, Senior Counsel, is my guest here, and when we started talking, he made it very clear. I am the president of the Law Association, but my view is not one shared by all the members of the Law Association. In understanding some of the objections here, could you articulate for us what primarily seems to be area of disquiet among your membership with regards to the adoption of the Caribbean Court of Justice as the final appellate body?
I think the main area of disquiet of the membership, from what I've heard from among certain members, has to do with the argument that we're not ready. That is to say, members of the Law Association of Trinidad and Tobago, practicing attorneys in Trinidad and Tobago, who daily have to deal with the administration of justice, the domestic administration of justice, on behalf of their clients, whether it be going to court and being susceptible to delays, whether it be going to court and finding inefficiencies in the system, or trying to get a conveyance through for purposes of land transfers or something to do with the corporate registry. Members of the practicing profession of Trinidad and Tobago have legitimate concerns about the fact that our domestic administration of justice system is not functioning as efficiently as it should. A very glaring example of that, and one on which the Law Association has very grave concerns, is the criminal justice system. The state of play on remand yard. How many innocent young people who are on remand yard, who are in jail without a trial for upwards of 6 to 10 years, have not yet had an opportunity to be pronounced guilty. They are presumed innocent, but they're still in jail.
Senior Counsel, forgive me for a moment, because while I follow that, I'm as I said, my coffee does not always work best in the morning. I'm looking for the juxta on that onto the Caribbean Court of Appeal, because yes, I can see a lot of things to be fixed and corrected in our local situation, but what does that have to do with the Caribbean Court of Justice? Forgive me.
I'm very glad you asked that question, Rennie, because I was actually about to say, but, however, that has nothing to do with the Caribbean Court of Justice. So while I respect the legitimate concerns of the membership that our domestic system needs to pull itself up at the bootstraps in many respects, I think that the concerns that are being articulated, while legitimate, cannot be taken across to the Caribbean Court of Justice. And that's why I think, and I'll tell you something, in the symposium that we had in earlier 2015 among our membership, I was shocked to discover how little our membership actually knew about the Caribbean Court of Justice, but were vehemently opposed to it. Yes. I was genuinely taken aback when we put the debate out there to our membership to say we're having this discussion, come and be part of the discussion. I was shocked to discover how many people had not read the instruments which create the court, had not read the decisions of the court, 10 years of decision, and therefore were pointing to decisions of domestic courts across the region as examples of why the CCJ was not yet good enough, having not read the decisions of the CCJ. It's an educational process which we undertake as the Law Association a responsibility to embark on for our membership.
I'm going to channel Yogi Berra here. It's deja vu all over again. Because if you speak to many people of the Federation era in Jamaica, they would say, well, I didn't really know what it was, but I was told everybody would become a ward of Jamaica, and as such, I objected to it. I was told they will take our jobs. I am told that we would have to subsidize them, and it is frightening. It is frightening to hear that those of higher learnings have not taken the time to understand what is involved in this very important initiative for the people of the region.
That takes us back to the question of a referendum, and the most current example of that is Brexit. Right now, the BBC actually has embarked on a program. They call it the Disunited Kingdom.
Yes.
And they're going into the country and talking to people to try to form an understanding of what the people of the United Kingdom actually understand about the European community at the point at which they were asked to vote whether to stay in or to stay out.
A condition that is now called buyer's remorse.
I won't go there. But the short point is that we as a law association recognize that we have a responsibility to our membership and by extension to the public of Trinidad and Tobago to mount national discussions so as to promote information so that the population of this country, our membership, will make a rational, informed decision as to now, not when. Because if we leave it too late, it will be too late, as it was the case of the Federation.
On behalf of all the listeners of 107.7, I thank you so much for taking the time this morning to really detailing, contextualizing the whole argument, the whole discussion of the CCJ. I will ask you, though, in particularly where you sit, in conclusion, what is your prognosis for the CCJ's adoption by Trinidad and Tobago?
Well, my prognosis is that it is inevitable. One of the things that the CCJ is doing throughout the Caribbean is actually embarking on rehabilitation exercises with domestic courts to strengthen the domestic systems around the Caribbean. I think that the prognosis has to be a positive one. I'm an optimist at heart. We have to take charge of our affairs, and we cannot, as a 50-year-old nation, expect that we will tell our children 20 years from now that when we were asked to make the final decision on taking charge of our affairs, we preferred to leave those decisions at 10 Downing Street.
These, I think that's a good area of departure right there. These areas of informing the public. You say you're going to have national outreach.
Yes.
They're going to have national outreach. Wherever we can assist in that area, feel free to call on us. I truly appreciate you taking the time to be with us here this morning.
And once again, I congratulate you on this initiative. Thank you. It has been a privilege.
And you have a wonderful day. The privilege was indeed ours.